going back to the team. Large team, we're growing, and not necessarily in the lockdown belly sense. We have a number of leading individuals, people that are ranked in both Chambers and Legal 500, and Ian, who is obviously my co-host, is ranked personally, so well done, Ian. We have a number of very experienced operators in the team. Some familiar names may include Richard Bagwell, Mark Richardson, Tracy Bailey, Helen Thomas, and that's just to name a few. Both Ian and I routinely deal with landlord and tenant matters. It's part of our day-to-day work. In addition to that, I've got a particular interest in development and development site issues, and Ian is an agricultural specialist, and as I understand, Ian, you're a fellow of the Agricultural Law Association.
Yeah, that's right, yeah.
Which I understand you can't buy from eBay, so presumably means you know your stuff.
Not anymore, no.
Okay, good stuff. Well, so he knows his stuff. Anyway, that's the intros over and done with. Let's get down to business. So this is what we're going to look at today. We're going to give you a brief overview of the remedies that are usually available to landlords, the effect of COVID-19 on those remedies, economic pressures, what we're finding as sort of current trends, and we're going to have a little practical example which we're going to work through and apply some of the stuff we've talked about today to. And then, as I said, there'll be a Q&A session at the end. We want to try and make this as interactive as possible, so please do chip in if you have any observations or thoughts generally. Now, obviously, COVID and the current economic climate has created a lot of uncertainty. We're going to try and provide a little bit of clarity where we can. Now, before I get into the issue of rent and rent arrears, which is generally the most pressing concern, have a quick read of this sort of example. Keep it in your heads. We'll try and apply some of the stuff we talk about at the end, but you might find it useful just to note that scenario down as we go along. So imagine there's a tenant of a shop on the high street. Tenant's an individual, it's a full repairing and insuring lease, and there are rent arrears which have accrued since March of this year. Let's call it 15k to date, and the property's in a bit of a state. So as the slide says, we'll come back to that later, but just park that for now and just take that on board. So rent. Now, I read something in the FT, or I think it was the FT a few weeks ago, about recovery levels for, I think, retail rents, and I saw a figure, someone suggesting it would be 60%, or as low as 60% following the September quarter day, so pretty bleak. I mean, certainly in terms of the things we've seen coming through our door, there is clearly a lot of landlords, or there are clearly a lot of landlords that are keen to push the recovery of rent, some more aggressively than others. There are equally tenants that are approaching us for help to negotiate with their landlords or to try and sort of slow things down a bit. So there is plenty of that work coming in, but what is pleasing to see also is there is an element of collaboration. I'll come on to that in a bit. But understandably, rent is at the forefront of most businesses' minds and most people's minds at the moment. Before I sort of talk through the COVID impact and what you can't now do, I'll just give you a quick overview of the usual remedies that are available to a landlord where a tenant hasn't paid rent. So essentially there's sort of 5 options in all. Option 1 is probably the most straightforward. It's to sue for the debt, bring a county court claim, you tenant owe me some money, whatever it may be, and to pursue a claim in the court. Now that of course takes time. There's always a chance that a tenant could put in a defence, and you could be looking at months before you get a judgment. Even then, once you've got your judgment, you've then got to work out how you're going to enforce it. So that's an option commonly used, relatively cost effective if you put it through a debt recovery type firm. And the one advantage, or it could be a disadvantage depending on which way you see it, is that the lease continues. The second option, which isn't used all that frequently, is what we call CRA, commercial rent arrears recovery. And that essentially replaced what was distraining on goods. It's where you go in and essentially levy on goods belonging to the tenant. You've then got the third option, which is forfeiture, essentially bringing the lease to an end. And just going back to CRA, of course, with commercial rent arrears recovery, the lease continues. Forfeiture, the opposite. The lease is brought to an end, and that can be done either by peaceable re-entry, going in and changing the locks, or by issuing court proceedings. You've then got insolvency, and that will commonly include, if it's a company, a winding up petition, or if it's an individual serving a stat demand and then following through with a bankruptcy petition. Now finally, and this is not always applicable, but there's the rent deposit. If you have a rent deposit and you can use it, use it. I'll come on to the COVID implications of that in just a moment. So there's your 5 options: suing for a debt, commercial rent arrears recovery, forfeiture, insolvency, and use of a rent deposit. Now, obviously, things have changed a lot since March of this year. We've had the Coronavirus Act, we've had CIGA, which is the Corporate Insolvency and Governance Act, that's put a stop on certain actions being taken. And I'll now run you through the 5 options I've just set out. I'll now run you through how those pieces of legislation have impacted on those remedies. Now, suing for the debt, that's still fair game. That still can happen. Not much has changed in respect of that, although we have found that because of COVID, the courts are in a bit of a go slow. They were never, depending on which court it was, that quick. They have become a lot slower in processing things. And of course, question as an enforcement method as a landlord, how bothered the tenant might be by that if other debts are on top of them. I mean, it's going to be a number of months before they get a judgment, and probably a number of months thereafter before you are thinking about enforcement action. So if people are using it, not a great deal. The threat is often used, and of course, if you've got a guarantor, the threat of suing a guarantor under the lease can often be an effective method for a landlord. Now, in terms of commercial rent arrears recovery, that can still be used, but there's some strings attached. Essentially, from September, you had to have at least 276 days outstanding before you could use CRA. That is going to be increased to 366 days from December. It's essentially keeping in line with when things kicked off with COVID. So if you're going to use that as a remedy, you're going to need to do a bit of maths on that, but it is still an option. Now, forfeiture, and Ian will pick up on the nuances in terms of forfeiture and other breaches in a moment, but forfeiture for the non-payments of rent is a no-no, and is a no-no until the end of this year. Now, you'd have seen the recent announcements about furlough being extended till March. We think, no one can be sure, but we think the moratorium on forfeiture is going to be extended further, and it wouldn't surprise us, and we were talking about this amongst the team recently. We think it's going to probably be extended till March of next year, but we'll see, and I'm sure there'll be an announcement from government on that in due course. Now, in terms of insolvency, it's slightly complicated. In terms of individuals, so if you've got an individual tenant and they owe a sum of over £5,000, as you were, you can do a stat demand and make them insolvent. If you're a company, a corporate entity and a tenant, and your landlord wants to come after you by way of insolvency proceedings, then you can do a winding up petition, but CIGA says that the obligation's on you as the petitioning creditor to show that the sums that are outstanding can't be paid for reasons other than COVID. Now, that's going to be really hard to show, and you might think, well, okay, this debt was pre-COVID kicking off, so surely it's fine. Well, not necessarily so. It's potentially open to a tenant to argue that they would have had the money in March, April, whenever it may have been, but for COVID, they cannot now pay what is a historical debt. So it is tricky. We're running these sorts of points for clients, but there is no real certainty at the moment, and there isn't a great deal of guidance on it. So I'm just going to add someone else to the session. Okay, right. So that's insolvency. Now, rent deposits, again, you can use the rent deposits if the lease provides for it. That's absolutely fine. And usually the lease will provide that the tenant is to then top that rent deposit back up. Now, there's an interesting point there. Is the requirement for the tenant to top that deposit back up a non-payment of rent breach, or is it a breach that falls outside of the Coronavirus Act and the restrictions there? So again, there's some technical points to raise, and we're running some technical points for clients writing for at the moment. So that is a bit of a very high level overview of remedies and where we are at the moment. Now, before I move on to Ian, or Ian talks about other breaches under the lease, I want to quickly mention rent concessions. And these have been commonplace really in recent months. I've probably helped at least 20 different clients formalise rent concessions. And what do I mean by rent concessions? So that's the waiver of rent. Landlord may say to tenant, look, don't worry about it, we'll pick things up again in a few months' time. It could be landlord saying, yeah, okay, look, we know you're struggling. We will defer the rent until X date and have a plan in place so you can clear it over a period of, say, 12 months. It's advantageous to both landlord and tenants to formalise this if you can. You want to protect your rights to do other things in the lease. You want to preserve rights against guarantors. And you want to think about things like trigger-free payment. What if there's a default on one of the instalments? What's going to happen then? So there's lots of things to think about. And as I said, it's probably to have this set out clearly in one place so that both parties know what they're dealing with. Now, on that point, we at a very early stage put together as a team a sort of a precedent rent deferment letter with some guidance notes. By all means, after this session, if you would like to have a copy of that, we're happy to send a copy to you for you to use for your clients and yourself. And of course, we can be on hand to give you a steer on anything in particular that's of concern. So as I said, just drop us a line, either me or Ian, and we will then get that to you. So in summary, and to wrap up the bit I'm talking about, there are still options available to landlords, but of course, those options are somewhat limited. Collaboration, I think, is going to be key here. And I think before you think about lawyering up, and I'm not trying to do us out of work here, I think before you escalate things, really try and explore whether there is scope to use your landlord-tenant relationship to reach an agreement. It's neither going to be in the landlord's interest in reality to pursue every penny, and it's neither going to be in the tenant's interest to really bury their head in the sand. So the more you can talk, the better. And one thing I was discussing with someone earlier is whether, if the relationship isn't great, whether someone could step in and help to mediate. And that might not be a lawyer, it might be a property agent, and you might want to get someone in to help you in facilitating those discussions. So that's just again a whistle-stop sort of tour of remedies and my thoughts on rent. I'll now hand you over to Ian to talk about other breaches. Ian.
Thanks, Ben. I particularly like the use of lawyering up there in the current context of what's going on in the world. Obviously, something we're all probably thinking about. Just following on what Ben said, there's an interesting point, of course, is that when you are pursuing things, then it's always worth looking in the lease to see whether or not there's cost recovery clauses, because again, that can have a big factor upon it. But like Ben said, it's always best to reach some sort of agreement. And like Ben, I've had a lot of clients I'm acting for and assisting in relation to rent issues. But what I'm going to talk to you about is other breaches, so effectively non-rent breaches. And what Ben's been referring to, and I don't want to bore you with law too much, but it's Section 82 of the Coronavirus Act, which is what introduced these restrictions in relation to how aggressively landlords can terminate leases and pursue rent arrears and all those sort of issues. And Section 82(1) basically says that the restriction applies to the non-payment of rent, and it doesn't really go into any detail about the non-rent issues from that perspective, so i.e. other breaches. So effectively, the law is exactly the same as it was before. So if you've got a landlord that says, actually, I could do with just getting rid of this tenant, I don't want them anymore, then in some ways, even if there are high rent arrears, it's best to look at the other issues as such, because the law still applies. And the only difference really for forfeiting a lease, for example, in relation to this, is that we need to follow Section 146 of the Law of Property Act 1925. So serving our Section 146 notice and getting through in that way. So one other thing that's worth bearing in mind as well, and Ben mentioned that I'm an agricultural specialist. Yeah, I do that. The interesting thing about Section 82 again is that it only applies to tenancies that are covered by the 54 Act, the Landlord and Tenant Act 1954. So that will cover commercial properties, and that includes both protected and contracted out leases as well. So even though they've been contracted out, they're still covered by this Section 82 protection. But if, for agricultural tenants, they're not protected by any of this at all. So that they're at risk. But if you've got people that are occupying commercial premises on a license, or a tenancy at will or something like that, then they're not necessarily covered. So that's something to bear in mind as well in relation to that. So say, for example, there's a breach because there's disrepair or something like that. We could serve a Section 146 notice. And if that's not complied with, then yes, we can go ahead and forfeit in principle. And that's a really powerful remedy, still open to landlords. And one, we're tending to advise a lot of landlords about that, especially if they want to get rid of the tenant, if they've got someone who's willing to move in and willing to pay, because their business perhaps isn't as affected by the lockdown provisions as the existing tenant. One thing to bear in mind, of course, is that with a Section 146 notice, you need to give the tenant a reasonable opportunity to remedy the defect, if of course it's a remediable breach. So we will need to bear in mind any effect of COVID on this. So of course, if they need a bit longer than normal, that's something we'll have to factor in. But again, that's something we can deal with as and when we come to serve the actual notice. When it comes to forfeiting itself, there's no difference really at the moment, other than we need to comply with the general restrictions concerning coronavirus, so making sure that we don't breach those other laws. It'll be interesting. I feel sorry for the High Court enforcement officers at the moment, because of course they've got quite a tricky task. Their job centres around doing some of these jobs that perhaps some of us wouldn't want to have to do, like evicting people and getting money out of people, all this sort of things. But they've still got to make sure they comply with all the coronavirus restrictions. And I've had various people asking for advice, and a lot of the High Court enforcement officers are saying, they won't go if someone is obviously positive with coronavirus, if they're isolating or if they're shielding. So we're seeing some tactical people saying, "Oh, I'm shielding. You can't come in." And this is making a particular difference when it comes to residential properties. But my understanding is that they're more keen to go in where there are commercial premises. So that's still open to use. But in any event, some people do forfeit without using High Court enforcement officers. They'll go ahead and get a locksmith, and they can do it themselves. But obviously, you need to make sure that you follow the right procedure by serving the right notices and dealing with things afterwards. So that's a bit about repair and a bit on forfeiture as well. I've put there about keep open clauses. These are quite interesting. I think this affects more bigger shopping centres perhaps than others. But of course, people are saying, well, I'm going to be in breach of my lease if I don't keep it open. Well, the usual remedy would be an injunction for non-compliance with this. But there is case law to say that when you do breach a keep open clause, it's more likely that the landlord will be entitled to compensation rather than that. And the difficulty that a landlord's got at the moment is proving the cause for the loss as well, because there are some good arguments that can be made saying, well, look, yes, I'm in breach, but the law's there. You couldn't open the building anyway, and therefore, is your loss caused because of coronavirus, or is it because I've breached my covenant? So again, if anyone wants to discuss that later on, I'm more than happy to discuss that. But I don't think that affects us so much down this end of the world, as it were. But some very interesting arguments can be had there. Now, I've put there compliance with laws such as health and safety and all those sort of things. There generally is within most leases some sort of clause saying that the tenant must comply with all laws that apply at the time. And similarly, that's going to cover everything that's going on now. So it'd be interesting, perhaps in the Q&A session at the end, just to have a discussion about how that's working in practice between landlords and tenants, and whether there's any pushback. And that kind of leads us on to the next point, which is service charge, because we've all been into shops and we've had to go in and sanitize our hands, and then follow the barriers, and there's all this tape on the floor with arrows that everyone seems to ignore, and no entry signs that we all don't seem to follow, or anything like that. This is all costing money. And even when I was walking around Truro the other day, the security guards with barriers and that, and this is all costing money. And I know perhaps that's on the public road, but if you're in a shopping centre, or if you're in a big area, this might be covered by a service charge. So again, it comes down to what the contractual provisions provide. We need to look at the contract first and foremost, and see what it says. But in principle, it might be that the landlord has to show that this is reasonable, the incursion of these costs, in order to comply with the requirements. So again, if a tenant doesn't pay their service charge, they are at risk. There may be a possibility there of serving some sort of Section 146 notice to get through. Put in there as well about alienation. I don't know how people are experiencing this, but obviously we're hearing about people trying to minimize their losses by taking in other people to help them or basically make some money whilst they can operate their normal business. Again, all the usual provisions apply, and we need to make sure that we check carefully on the lease so far as that's concerned. So if we can go on to the next slide, please, Ben. There we go, lease renewals. Obviously, none of this stops in the meantime, and I'm sure Ben's done the same, but I've served quite a few Section 25 notices during lockdown. One thing I've not put in is about break notices, and again, we can have a chat about that later on, but all of this is still going on. Leases are coming to an end, and there's no reason why this shouldn't happen. Out of interest, I mentioned Section 82 of the Coronavirus Act earlier. Subsection 11 of that provides that if you're going to try and challenge a lease renewal on the basis of rent arrears, then you cannot rely upon any rent arrears that have accrued during the lockdown period. So effectively since the relevant period started, which was the 26th of March this year. And as Ben said, it goes until the end of this year. We're expecting that relevant period to be extended up until at least March, and it might go beyond that. But at the moment, if you're going to try and rely upon rent arrears, then you're going to have to rely upon pre-lockdown arrears to try and make out your ground B notice there, as it were, in relation to anything of that. General economic pressures are something to weigh into the balance when you serve a Section 25 notice anyway. Is it the right time to serve it? And now is as much the case as any others. But one of the things that's relevant is interim rent that we put there, because of course it is possible to apply for an interim rent after you've served your Section 25 or Section 26 notice. And irrespective of who serves the notice, either the landlord or tenant can make an interim rent application. And the interim rent is going to be payable from the earliest date that Section 25 or Section 26 notice could expire. So in some ways, if a landlord serves a Section 25 notice, they might end up with a tenant making an application for an interim rent, saying, well, hold on a minute, I'm paying you £30,000 per annum. Given everything that's happened, I should only be paying you £20,000. So they could end up facing an interim rent application that actually presents a bit of a problem to them. So that's something to be very aware of, I think, as and when you're serving your Section 25 notices, or if you've received a Section 26 notice from a tenant. We're seeing landlords thinking, well, it would be good to get the tenant tied up to a new lease. They may want to have that longevity going forwards, thinking, well, retail's taking a bit of a hit anyway, and we've got coronavirus. Yes, I will accept a lower rent as long as they agree to another 5-year term or something like that. And we're seeing quite a bit of that as well. So again, it'd be interesting to discuss what other people are experiencing in the market and how that's going. So interim rent, something to think about as well. I've put in there about COVID-19 clauses. This is something that is coming up as well. People are saying, well, should we not be including a clause in new leases going forwards to cover this happening in the future? Because all the news is that coronavirus might be here to stay. It might happen a bit like the flu year on year. Well, there's quite a few things to think about that. The sort of issues that arise is that, well, what is it going to cover? And how does it apply, and when will it apply? Because in some ways, some of the suggestions, for example, one of the classic ones is to have an automatic rent reduction when there's a coronavirus outbreak. Well, the drafting of that's a bit of a nightmare, quite frankly, because until there are some workable clauses, there's going to be a lot of argument over it. And you can see just an example from the insurance side of things. There's an insurance test case going on at the moment about whether or not insurance companies have to pay out for business disruption at the moment. That's costing millions of pounds to the insurers. Well, this is a smaller version of it. It's going to concern whether landlords are going to be entitled to their rent, and especially as well, they might have an insurance back to cover that as well, which is something else to bear in mind. But other things, like landlords not enforcing the repairs during a lockdown. Again, well, what happens? Could a landlord go in and use their rights under something like a Jervis and Harris clause? So they could actually do the works and then sue for the difference. Another one that's mooted is, well, the tenant shouldn't have to yield up, i.e. give up the tenancy during a lockdown period, especially if they're going to find themselves in some difficulty, if they're shielding and all those sorts of things. Well, what happens afterwards? What happens if they pay rent? Would there be a new tenancy created? There's a lot of things that need to be factored in to be thought about this. And at the moment, we're kind of still working through this as we go, but there must be a question mark whether or not any sort of coronavirus 19 clauses are of any kind of benefit at all. Then that leads to the next thing is, well, even if we want one and we've got an existing lease, can we have one? And the answer is, well, possibly not, because leading case on this is O'May and City of London Real Property Company. And the basic premise of that case is that, we start with the lease that exists. And if anyone wants to change a provision with that lease, in the new lease, they have to justify it and they have to show that it's fair and reasonable in all of the circumstances. So yeah, coronavirus is a new issue, and I'm sure that would be a factor taken into account. But ultimately, it's only one factor that the court will weigh into the balance. So there's no guarantee that you would actually end up getting your COVID-19 clause in any event, in any lease renewal. So that's something to bear in mind. Just as an aside, we're seeing quite a few people opting for turnover rents now to try and entice tenants in as well, which is an interesting thing. And I think we're probably going to see a few more of those going forwards as well. So yeah, that's there. And as I put there at the end, timing and market conditions, then that's something to bear in mind generally, but that's pretty obvious. So yeah, there we go. Ben, back to you.
Cheers, Ian. Right, so going back to the example we shared at the beginning, appreciate there's a lot of information there. Ian and I could probably talk about this for hours, to be honest, and I'm conscious of time already. We're a couple of minutes over, so we'll try and wrap this up as quickly as we can. But just going back to the practical example there, two questions. In light of what we looked at, can the landlord look to forfeit the lease? And the second question, can the landlord pursue the insolvency of the tenant? So let's deal with it in reverse order, the insolvency point first. You'll see there the tenant's an individual. Going back to what I said, it's fair game to pursue the insolvency of an individual at the moment, provided the arrears are over £5,000. And clearly there they are, over £5,000. So to answer the second question, yes, in this example, a claim, or rather a petition or stat demand first, then a petition can be pursued. Now, can the landlord look to forfeit the lease? So, hang on a minute, what's happened there? Right, sorry. Can the landlord forfeit the lease? The answer there is yes, in theory. And going back to what Ian said, so on the rent point, no, can't forfeit for the rent. But you'll see there it's a full repairing and insuring lease, so that there's a requirement on the tenant to deal with repairs. You'll see there the property's in disrepair, so there's a breach. So you'd serve your 146 notice. Again, being mindful of giving them a reasonable period of time, what's reasonable in the circumstances you have to assess, given the factual background. But you could, in theory, do the 146 notice if the works aren't done. You could forfeit the lease by way of peaceable re-entry or by issuing proceedings. So, I mean, again, appreciate that's a very, very quick application. But I'm conscious of time. We may revisit this again in a moment, depending on if there's any questions or an appetite to do that. And now time for questions. So if there are any questions, feel free to either put it in the chat box or to unmute yourself. Hopefully you can unmute yourself. Don't be shy.
It's interesting, Ben, just on that example that we did as well. So what would be the case then if it wasn't an individual tenant, so if it was a corporate tenant?
Well, if it was a corporate tenant, in terms of forfeiture, it would still be on. You could still go through your 146 process. But of course, going back to what I said earlier, you've got SIGA and the restrictions on winding up petitions. So that 15K, you need to get to the bottom of how that came about and why it was owing, essentially. And if you're going to succeed with that as an option as a landlord, you need to be able to explain to the court that sum fell due and it can't be paid, not because of COVID, but for other reasons, i.e. there'd be bust regardless of COVID. So that's how it would differ, I think, in light of that. Yeah. Don't think anyone's put, unless I've missed anything on the chat, I don't think anyone's put any questions. So I think we'll probably wrap that up there. Thanks everyone for joining us. Appreciate it's been a rapid canter through everything. If you want to pick up the phone, bounce ideas, then Ian and I are always available to have a chat. Oh, hang on a minute. Adam's raised the question here. Sorry. For new leases being entered into now, what sort of lease length is being asked for? Adam, to answer your question, in my experience, it tends to be fairly short. And if it's longer, there's breaks in there.
Yeah, I'd agree with that. The ones I've seen are pretty short, so we're talking like 2 or 3 years, that sort of thing, and usually pretty heavily stacked for tenant breaks and things like that as well. It seems to us, I mean, you guys, and some, not all of you obviously, but quite a lot of you are agents. You guys are the experts. It'd be interesting to hear what you're seeing, but we're seeing it very much being a tenant's market at the moment. You know, and landlords are the ones, you know, doing most of the hard work.
Anyone else? Doesn't look like it. As I said, so Ian and I, if you want to just bounce an idea or have a problematic issue you want to run past us, pick up the phone. Always happy to have a chat, and hopefully that's been of some use to you today. So unless anyone's got any last minute questions, I'll end this call. So thanks for joining and enjoy your weekend.
Thanks everybody. Oh, hold on. Covert clauses are prevalent. That's interesting. So, Mike, that's very interesting for you to say that. It'd be interesting just to hear as well, when you say covert clauses, what are they actually covering? You know, because I gave some examples of, you know, rent reduction, or, you know, the inability of a landlord to enforce certain things. How extensive are these covert clauses? Rent reduction, right? Okay. Interesting. Yeah, I mean that's the main thing, of course. You know, rent during the lockdown, that's where people have struggled. But yeah, that's interesting to know that is becoming more of an issue.
Yeah, thanks, Mike. Right, good. So yeah, again, conscious of time, so we'll wrap this up. Anything else, like I said, just ping us an email or pick up the phone. Thanks all.
Thank you very much.